Hi, everyone. Can you hear me in the back? Is my mic on? Hi, I'm Whitney Jones-Roy. I'm the managing partner of the LA office of Sheppard Mullin. I'm a litigator, and my practice is split between commercial litigation and environmental litigation. And I have three wonderful panelists that have joined me today. Why don't we start at the end and let each person introduce themselves. First is Jennifer Jackson from Bryan Cave.
Hi, thank you. My name is Jenny Jackson. I am a partner at Bryan Cave. For the past 7 years, I've been the managing partner of the Los Angeles office. And starting next week, I will become one of the co-leaders of the firm's commercial litigation practice group.
And next we have Liz Atlee from CBRE.
I'm Liz Atlee. I'm the Deputy General Counsel for Global Litigation at CBRE. And I manage litigation all over the world, I guess, what my title says.
And finally, David Gallagher from Bentham.
Hi, I'm David Gallagher, an investment manager and legal counsel at Bentham. We're a commercial litigation funding company. I and my colleagues help find good, strong commercial cases to invest in, and we help the company decide which ones are worth actually making the investment in.
So when we were asked to speak today, we were challenged to talk about litigation management, particularly in an environment where the goal is to manage risk for the client or the company, but still reduce litigation costs. So we have a few different general topics that we're going to discuss, and the first one is the process of selecting the right counsel, keeping in mind the idea of trying to minimize litigation costs. So maybe Jenny or Liz, do either one of you want to start with that?
Sure. I'll go first. So one of the things that I do in managing litigation is help select counsel for appropriate cases. And we have a couple ways that we do it at CBRE. One is we have what we call a jurisdictional provider list. And as the last panel said, it's kind of a preferred provider list, but not really preferred. It's just we know that there are lawyers with certain expertise in certain parts of the region. So depending on the size of the case, we'll go to those lawyers that we've pre-vetted and pre-negotiated prices with, whether they're AFAs or discounted hourly rates. The second way is if we have a larger litigation matter or a large transaction, we'll send out an RFP. And in that RFP, we have 6 or 7 points that we ask the law firms to opine on. Why is that good? One is we can get a little bit of free legal advice. Probably shouldn't say that to this room. But it's really great to see how different firms kind of attack the same problem. 2, we have apples-to-apples comparison on fees. 3, that's how we've gotten some of our best AFA ideas, is from law firms submitting those. So when they're creative ideas in that, we tend to sit up and look at those. And then 4, we have a diversity initiative that we like to follow. So we like to see how diverse the group is that's being set forth. So we generally don't go necessarily to the lowest price firm, but if a firm meets all of those different qualifications, then we'll choose them from our RFP process.
And Jenny, being on the other side of it, what sorts of things are you doing in order to be selected as that go-to firm?
Well, we're seeing a lot of pressure to come in to respond to RFPs, not necessarily to be the lowest cost provider, but to provide the wide range of services that the client needs at an effective price that is fair for both the firm and the client. So for example, some of the clients are looking to us to respond to an RFP for all of a certain type of litigation. And that might be either pursuant to some sort of a flat fee arrangement or capped fees or something like that. And so we're going to be we're going to work with our practice economics group, which is a group that's devoted to analyzing our practice and what we can and can't do within a certain fee arrangement, and is this workable for us? And they will help us respond to the proposal with a team, who are going to be the best people to manage this work, who are the most efficient, how can we monitor and really manage this work to make it feasible, profitable basically for the firm, but still accomplish the client's goals. And that last piece is important because depending on who the client is and what their goals are, they may be looking to settle a lot of litigation. Maybe they're trying to protect reputational risk. Maybe they have a lot of cases they just want to get rid of. Or maybe they're really trying to, set a standard and say, no, we're not going to be paying people for these claims. So it just depends on what it is the client's looking for, but we are being more and more strategic about analyzing that up front so that we can present something to the client that we feel comfortable with and that is workable for the client as well.
And David, how does litigation finance really factor into the selection of counsel?
Sure. First, I'd just say that I think it helps factor into the selection of what case will be brought. Litigation finance can be used on the plaintiff side or the defense side, but as you might assume, typically it's more appropriate on the plaintiff side. And many companies just don't file plaintiff side litigation unless it's a make or break case. The general counsel's office has a limited budget, and I think it's a tough sell to say, not only do we have to pay all of these defense side fees in cases where we couldn't avoid getting sued, but we'd like to bring our own lawsuit, which is going to cost us X number of millions of dollars. So the availability of third-party litigation funding can make it possible to bring a meritorious plaintiff side case that a company might otherwise have just sort of let the value of the claims lie fallow. And to the choice of counsel, litigation funding is a great tool for companies to use to enable them to afford top quality counsel and the best experts, and really at potentially no cost to the company at all, other than as a share of the proceeds of any success in the litigation. And it's also a term for firms to use to win engagements with new clients, because in partnership with a funder, a firm can offer a blended fee. It can offer what, in the experience and perception of the client, is a complete contingency arrangement, and it may be able to basically build in one or another form of a discount or an alternative fee structure with the support of a third-party funder.
Now, when we get to the point of actually getting the case assigned to a particular counsel, I'm interested in hearing from you, what sort of techniques are you employing to manage the cases in order to keep the costs down for the client? Jenny, do you want to start?
Sure. Back in what I'll kind of loosely refer to as the good old days, there may have been, a case that comes in and the partner kind of, takes control of it, is running with the cases, maybe even is doing the briefing, taking all the depositions, arguing, and so forth. And certainly, in big cases, that's still the expected model. In some of the cases that I was referring to earlier, where we're really trying to do a volume of litigation, or where the pricing pressures are particularly high, it might look more like the case comes in and a senior lawyer reviews the case, maybe spends some time strategizing, what's the best use of our resources here, what's the client's goal, what are they trying to accomplish, and then who on my team is the best to really run with it. So we might be seeing our junior lawyers take a more active role in dealing with the opposing counsel, arguing in court, taking the lead on drafting and things like that. Of course, with supervision from the partner, but with maybe a less active role than what the partner or more senior lawyer may have had. The other thing that we found is really important, regardless of who's handling the matter, is to be constantly checking back in against the budget. Where are we with the fees, and how are we managing that? And I think Brad alluded to it on the last panel, which is this notion of having real-time access to what you've incurred so far and what's left to do. And the other piece that's important, of course, is to communicate that back to the client. Here's what's going on, here's where we are so far, and occasionally you might need to either revisit your budget or your strategy, depending on what's happened in the case, but it's a paying attention to where we are, where do we need to go, and what's the best way to get there without just, bill.
How frequently would you say you're checking against a budget?
Well, it depends on the nature of the case. I would say probably from monthly, depending on if it, there's not as much activity going on or that sort of thing, or, could be weekly or even more often, just depending on the type of case and how active it is.
And Liz, from the in-house perspective, what are you doing to manage the litigation cost?
Well, first of all, what we do when a case comes in is we do an early case assessment. And so we have internal e-discovery capabilities. We go out, we grab what we can from shared drives, networks, email, whatever we think applies to the case. And then the lawyer managing the case in-house takes a look at that information, does an early case assessment, and kind of determines the direction that this case should go from a very early. We do it within the first 60 days. And then we hire counsel either alongside with that or just after that. When we bring the counsel in, we make sure that they're our partner in this. They understand our business, first of all. Very important to understand what it is. We have a lot of different aspects to our business. We have everything from janitors to very high-level producers working at CBRE. So it's important that they understand what the case is about, who is targeted, what are we defending against, usually defense. And then we manage from there. Together, we'll make a strategy. We'll get a budget, a strategy, and then kind of an evaluation from outside counsel. And that's a ratio, like 50-50 or 60-70 or whatever. And that all goes into our matter management system that's called, now it's called Legal Tracker. It's part of Thomson, used to be called Serengeti. And everything has to go through Serengeti. The billing goes through Serengeti. All of the updates go through Serengeti. That's what I can run reports of. You have anywhere from 300 to 450 matters around the world. So I run reports frequently. I often am asking counsel to compare, to look at the budget, because I can, in real time, compare what's pending and what's been invoiced to the budget. So if I see a disparity there, that's not good. So I ask to update. And I know with litigation, it's going to change over time. It's not going to stick with the ECA, but things might change. I ask for that to be updated as well. For a couple of reasons. One is we need to manage it, but two, I need to manage our insurance. So I need to make sure that they're on board, they know what their reserves need to be, et cetera. So that's pretty much how we handle most of our matters. We have a lot of good communication between our counsel that handle the matters day to day and outside counsel. But generally, we're partners. And if something's not working, we'll speak up. At least that's what I try to tell everyone who I work with. Time to tell them right away. Tell outside counsel immediately when something's not working so that we can get back on the right track. And if that can't get fixed, we can find other counsel.
Now, have either of you seen a change in perspective regarding preferences to try to settle cases early to manage costs versus sort of the more traditional sort of scorched earth litigation approach?
We generally will not do scorched earth. And it's our experience at CBRE and mine personally over the course of all of my years managing litigation that is not a very good way to go. It's unless you're a lawyer at a law firm, sorry. But for the industry, it's not a very good way to go. Generally, no rock unturned isn't gonna, the marginal difference of not turning over that last rock is not important. It's important to identify who the important players are, make sure you have that covered, make sure you're with the strategy, and if you can get the case resolved, I think there's been studies within the first 90 days, actually. You pay like 20% if you can get it resolved within the first 90 days of what it costs if the case goes longer. So we keep track of all those different metrics. We're not very good at settling things within the first 90 days, but we definitely don't do scorched earth in CBRE.
Jenny, how about you? What have you seen?
Well, it depends on the client and the issues involved. The past few years for me have been spent helping to manage a team of lawyers across the country that has been defending and handling litigation for a large financial services institution. So there have been a lot of cases, and so one of the goals has been to, have there be not so many cases. And so, settling early is one way to do that. And then, like I mentioned before, oftentimes the longer you go on with litigating, the more it's going to cost, not just in fees, but in settlement, but also in the risk to reputation, of the client. And so that it becomes more risky and dangerous the longer it goes on. So what we've instructed in a lot of our matters for the handling attorneys, often the junior people, pick up the phone. It's kind of the old-fashioned way now, but call up opposing counsel and say, what is it that you're trying to accomplish here? And see if you can't get to that early resolution. It's not always easy. So then the next step is often, what steps of litigation do we have to do to get it teed up for settlement? So again, we're not trying to have the trial of the century here. We're just trying to strategically position it to be resolved.
David, where does sort of the litigation finance perspective come out on pushing for settlement versus really litigating an issue?
So we would love every case to settle. We just want it to settle for what it's actually worth than to settle for an amount that a desperate, underfunded plaintiff has no choice but to accept. And I have seen, I'm not sure what's causing the feedback, we as litigation funders, we see many defendants who take a scorched earth approach, which is why so many parties on the plaintiff side need litigation funding. So I wish some of our adversaries were more reasonable. But the role that Bentham as a litigation funder plays in keeping costs under control, it starts really when we first look at a matter, and we work very closely with the client and with counsel to formulate a budget that's comprehensive and that's realistic. And once we're satisfied that the budget is likely to cover all eventualities or all reasonably likely eventualities, we then also play a useful role in getting some agreement from someone, maybe it's the firm, maybe it's the client, maybe it's us, but some agreement from someone as to who is going to pay if the litigation costs more than has been budgeted. And I don't know if this will be a surprise to some in-house people here, but we in that role have gotten AmLaw 100 firms to agree to cap their budgets in a litigation. We will fund you $3 million. The plaintiff will contribute, 25% or 50% of the budget. And once that money runs out, firms have agreed that they will be on the hook to put in whatever time it takes to get through settlement or trial. In some matters, the clients have agreed to pitch in if it goes over the cap. And in some matters, we've left it open-ended, so we might not have a commitment to do it, but we'd be able to step in and do it. But it's a very important conversation to have at the outset, not only what the budget will be, but what happens if the budget isn't adequate. And then, given that typically when we're funding a case, we're funding some or all of the fees and costs. In some matters, we can pay operating expenses too, but typically it's attorney's fees or costs. So it's our money that's being spent on the budget, so we keep a careful eye, and we have no control whatsoever over litigation strategy or settlement, whether an offer is made or accepted. But since our money is being spent on behalf of the claimant, we keep a very careful eye on the budget, and I think it is very helpful to have a sophisticated third party in that role to share the common goal with the claimant of keeping the costs under control.
So how closely are you monitoring the budget? How frequently are you checking in with counsel on their spend?
So after we've made a decision to fund, we take a very light touch approach to monitoring. And that's both in terms of the progress of the merits of the case and the budget itself. Because ethically, it's very important that we have no control over the decisions in the case. Those are up to the attorneys and the client, and we don't want to interfere with the independent exercise of professional judgment. But we will check in a typical case once a month, maybe once every 2 months if it's a slow period in the life cycle of the litigation. And we'll check in with the claimant and with counsel. And of course, all of these communications take place under a non-disclosure agreement, so they're protected as attorney work product. We don't put the attorney-client privilege at risk. We don't want to see any information like that, but we keep a sort of reasonably watchful eye, but from a respectful distance.
And I want to, before we move on from the topic of management, I want to circle back. Jenny was talking about staffing more junior lawyers and giving them basically more experience, more court time, depot time. And Liz, I want to hear from you in terms of what your view is on using younger lawyers, and has the role of a younger lawyer changed from your perspective?
It's kind of a conundrum, actually. I know that there are several companies out there that won't even pay for first-year lawyer time because they think it's useless. We're not there. I like to depend on the firm knowing their talent and saying in their budget, we're going to use this set of lawyers, let's say first through fourth years or whatever, to do this work, and we're going to budget it there. And then, these partners will come in, et cetera. We generally will hire a firm, as the last panel said, based on knowing that firm or the reputation of that firm, or if it was an RFP and they came in very strongly on some point of the RFP, and that's why we hired them, that's why we'll hire them. We're not hiring them for the junior lawyers. We're going to assume that they'll use the most efficient way to get the job done. That said, I won't pay a junior lawyer 25 hours for something that should have taken 3. And we have in-house, we have a person called the billing guideline reviewer. And so he will look at every single invoice that comes across Serengeti and compare it to the billing guidelines. And if there seems excessive billing, he's a paralegal, so he's familiar, he will mark it so that the next lawyer who's managing the case can agree or not agree, and then we dispute it back to the firm. We won't just write it off, but we'll dispute it back to the firm and have a conversation about that. So I guess my point is, if the work comes back and it's what we expect from that firm, and it's reasonable time-wise, I don't care. I mean, you could use a monkey if that's what you're going to have to use. But if there's a problem with it, and it happens more than once, then we should have a conversation on who you're staffing the case with. And I've had those conversations with firms. I know it can be tough when you're a junior lawyer to get the hours in, to become a partner or whatever, but you're not going to do it on CBRE's dime.
Well, that actually transitions us to our third topic, which is AFS and billing, and what you're doing with respect to that to manage the costs. So Liz, why don't you go ahead? I know we planned on for you to talk about this dedicated person responsible for reviewing invoices. Are there any other particular things you're doing on the billing end of things?
Well, like I said, we have Serengeti, well, we call it Serengeti, but it's supposed to be called Legal Tracker. And we have imposed that globally, which has made a few lawyers in different countries a little upset or shaken them up because I don't think they're at the same place that we are in the US. But we have imposed globally that they bill through Serengeti, and we review all of those bills. And we dispute them. There's certain tax treatments, et cetera, that we've had to struggle through, but we're there. We're getting to a point where we understand what our global legal spend is. And because of that, we have to keep really good track of rates, discounted rates, AFAs, how everything works. And Serengeti helps us do that by putting in the different metrics and whatnot. So we have the billing guideline reviewer. We have the next lawyer that looks at it. Ultimately, I look at every single invoice for litigation. And it probably takes 8 hours a week of my time to do that. So it's not a huge burden or anything because it's been vetted twice before I get it. But if I do see something I don't like, then I'll talk to the in-house counsel and we'll talk to outside counsel, et cetera. But that's a good way to do it. We also keep...
How often does that happen? But by the time it gets to your level, that there are still issues that you identify and go back? Is it frequent?
I would say probably like 5% of the bills have that. Sometimes because our lawyers like the people they work with. And so they're like, I didn't want to go back on this. And, I'm the heavy. So, but we keep track of how long things take. So we have, they're called UTBMS codes. And please don't ask me what that stands for, but it's a system-wide thing. And the lawyers need to assign a code to their work. So we can run reports on how long it took to take depositions, how long it took to do an analysis, how long it took to do just different tasks. And then when we do an AFA, we look at that to try to determine if the the fee arrangement's going to be fair to counsel because we are partners. We want to be fair. It's not like we want to be, bad. We need lawyers. We need people to want to work for us. So we use that to manage the cost up front and then also to check back in.
And Jenny, on the flip side of it, what are you doing to manage billing and AFSs?
Well, like I said, in terms of the managing the cases and the fees, it's a lot of monitoring. We've had enough discussions with the clients to know a lot of times what they can stomach, so to speak, in terms of a fee for a particular task. We've had those conversations back and forth. We were talking in preparation for this about lawyers on, in-house and outside both are more and more knowledgeable about how much a certain task is kind of expected to take. But we do our own quantifying of that as well by using the task codes. We'll have kind of our practice economics group will slice and dice and see, what's the average cost of a demurrer or a motion to dismiss, and who is taking much longer than that, and what do we do about that, and do we need to write down some of that time? And so again, it's just a lot of counting and comparing and monitoring and making sure that we're within the arrangement that we agree to with the client, but that we're also, not writing off excessive amounts of time and things like that.
And one other thing I think is that in-house we've taken away some of the kind of profit centers that firms have had traditionally, which is the copy room. So for example, CBRE, we're a green company and we don't pay for copies, period. Unless you have to send it to an outside copy service for some reason, like a production or something, then we'll pay for that. We don't pay for messenger services. Like, you should think ahead and be able to either put it in the mail or, use the way of doing it. We've also taken away the discovery profit center for the most part, and we have pre-negotiated rates with discovery services. So that when, if a time bomb goes off and we really need something looked at real quick, I can just pull out the MSA and point to it, call it e-discovery. We have an e-discovery specialist who is also formerly a paralegal, so she knows how to project manage it through. So we have really sliced off services from law firms and figured out ways to get around those profit centers for them.
David, how can a company use litigation finance to impact their litigation budgets or just impact their bottom line?
So probably the most obvious way to use it is it enables them to avoid having to pay for the litigation because it's a third party paying for the litigation. But it doesn't stop there. So we can fund up to 10% of the value of a claim. So for example, if a company has a $50 million claim, we could provide $5 million in funding. It might only cost $2 million to bring that claim. And that leaves $3 million that the company can do whatever it deems appropriate with. It could recognize $3 million in revenue, or it could, if the legal department gets credit for that $3 million, it could spend that $3 million paying attorney's fees for a defense side matter. So it's really a way it enables a company to really leverage the potential value of plaintiff side litigation claims. And maybe in a group of cases where it can be used to pay for the defense side litigation expenses too.
So how does it work, though? I mean, so, if I'm let's say Visa. I hope no one's here from Visa, or if you are, I'm sorry. And I wanted to bring the interchange claim. There's been that big litigation for a long time against American Express or whatever.
Okay.
So I go to you and I say, this is a $300 million claim.
Right.
What do you do? How do you finance it? What am I signing off on? I don't get it. How do you get paid?
So if you had counsel already who you wanted to work with on this, we would work with you and them together. If you didn't, we would recommend a number of firms who we either know are already working on a very similar case or who we think would be very suitable for it. We would work out a budget. we'd work out an agreement with the firm. A standard way that we do it is what we call our 50-50 model. So what that means is that the firm will lower its hourly rates by 50%. We, Bentham, will pay that 50%. So the client is paying zero. If the client can afford to pay costs, we'd like the client to pay the costs because that keeps the incentives aligned and the client doesn't feel that it's playing with free money. But if necessary, we can fund the costs as well. And then the law firm, in addition to having 50% of its hourly fees paid along the way according to the budget, it will get a 20% contingency fee out of any recovery.
I see.
And then this is of course all subject to negotiation, but in a typical deal, we as the funder, in return for having paid the 50% of the fees ongoing, we, through an agreement with the client, would also be entitled to 20% of any recovery. And then the client would be left, again, at no cost to itself other than perhaps the litigation cost or a fraction of them. The client in this hypo would be left with 60% of the recovery. If there's no recovery, then we've lost the money that we've paid to the firm. It does not have to be repaid. That's the risk that we take. The firm, at least, has had 50% of its time paid for, which, depending on the firm and its profit margins, isn't a fantastic outcome, but it might not be a terrible outcome.
So you must investigate the claim pretty thoroughly.
Yes, we do very thorough due diligence. Before I came to Bentham, I was a business litigator for 11 years, most recently at Aiken Gump in LA. And among the investment managers at Bentham, I have the least amount of experience with litigation. So it goes up from, some have 15, some have 20, some have 25 plus years experience as litigators. So we typically vet the claims ourselves. But if it's in some specialized area, legally or factually, say a patent case or an antitrust case, or maybe some kind of Medicare billing fraud, because we also fund whistleblower cases, we will retain outside counsel to help us diligence the specifics of that matter.
And you're global?
We are global. We started in Australia, and I'm happy to tell anyone the special reasons why. We started in Australia. We went public about 16 years ago. The short version is contingency fees are not allowed in Australia. And we've been in the US for the last 5 years, and in North America we have offices in New York, LA, San Francisco, Toronto, and we fund cases worldwide. Sometimes
we get cases in the UK where there's a conditional provider. I don't know if it's you or someone else. And I have to admit that when that happens, we think, oh, they pulled the wool over that guy's eyes, because we always think we're right. And it does.
When you're on the defense side?
When we're on the defense side and the plaintiff comes in with a funder.
Right.
It's usually called insurance in the UK, but I don't know if that's just you guys being called insurance. But it does make the plaintiffs bolder. It makes it a little bit harder to settle from a defense perspective.
Yeah, I can only speak for Bentham and its process, but we try, just given the fact that our funding is non-recourse and it does not have to be repaid unless there's a recovery in the case, we try very hard to only fund the very best cases. Mm-hmm. And so we turn down 19 out of 20 cases that we look at. And that doesn't even mean we win every single case or successfully settle every case that we're involved in, but we try very hard to avoid cases that aren't really compelling on the merits legally and factually.
It just makes it more expensive from my perspective.
Well, I want to thank all of you for your time. It was lovely getting to know you, and this was a fun session. Thank you.
Thank you.
Thank you.
Thank you, Whitney, and to the panel. We really appreciate your insights. We're going to take a 15-minute break. There's drinks in the back, so we invite you to get up, relax, get a chance to know the people in the room. As I said, this is also an opportunity for you to network with your peers. We'll reconvene in about 15 minutes. And one quick reminder, if for some reason you are leaving and you've applied for CLE credit, don't forget to sign out. You'll need to do that when you leave either the session or the reception later on this evening, okay? Thank you all.